Again, hello and welcome. I am Carlton Smith, the Education and Outreach Program Manager in the Fair Housing Project here at the Legal Aid Society of Palm Beach County. And we welcome you and we thank you for attending today's webinar. April is National Fair Housing Month, and this year's theme is more than just words. The nation celebrates fair housing in the month of April, just to honor the passage of the Fair Housing Act, which was done in April 1968, and gives us an opportunity to reflect on the efforts that were made leading up to the passage of the act and the implementation of the laws, and in trying to bring about fairness and justice for all individuals in terms of housing. We're excited to present this webinar to you today, which is entitled Litigating Your First Fair Housing Case. As mentioned in the advertising, the webinar will offer CLE credits, including an ethics credit. First, we want to thank for a generous donation. We want to thank HUD, which is a sponsor for today's activity. We also want to acknowledge the collaboration with the Office of Equal Opportunity, Palm Beach County, and then also recognize legal aid and the efforts that we make every day in fighting fair housing. Here at Legal Aid, our goal is to provide high quality civil legal advice, representation, and education to the disadvantaged of Palm Beach County in order to protect their personal safety, enhance their opportunities and living conditions, and promote self-sufficiency. At the end of the presentation, we will have time for questions. If you would please put those in the chat or in the Q&A box, and we will address those at that time. And again, this session is being recorded, and we ask that you, again, hold all your questions till the end. Right now, we want to go ahead and meet our panelists for today's training. First, we have Pamela Guerrier. Pamela is the director of the Palm Beach County Office of Equal Opportunity and has worked in that office since 2002. Mrs. Guerrier is responsible for managing investigation under the Palm Beach County's Equal Employment and Housing and Places of Public Accommodations ordinances. She supervises a staff of 11. OEO's jurisdiction covers all of Palm Beach County, which currently has a population of 1.3 million residents. OEO has contracts with the U.S. Equal Employment Opportunity Commission and the U.S. Department of Housing and Urban Development. And she works closely with the federal counterparts. Prior to working at OEO, she worked as an attorney with Legal Aid. Good. She is currently a member of the Florida Bar Association, the F. Malcolm Cunningham Senior Bar Association, and the Palm Beach County Bar Association. She is a past chair of the Florida Bar's Equal Opportunity Laws section and a member of the Palm Beach County Bar Association's Lawyers for Literacy Committee. She was a member of the Florida Supreme Court Standing Committee on Fairness and Diversity, which was established to help advance the state courts system efforts to eliminate bias from court operations. Next, we have Anita Jones. She is a Florida Bar attorney who is also admitted to practice in the Southern District of Florida. Her professional experience involves civil and criminal litigation, case management, legal writing, and risk management. Anita is a graduate of the University of Central Florida and Florida International University College of Law, where she served as president of the FIU Black Law Student Association, a member of the Public Interest Law Society, and FIU's trial advocacy team. As a former public defender and current staff attorney at the Legal Aid Society, Anita has a passion for advocating for oppressed, marginalized, and underrepresented groups. Her work at Legal Aid involves participation in community outreach and education events, advocating for victims of housing discrimination, and engaging in enforcement activities with regard to fair housing laws throughout Palm Beach, Martin, Okeechobee, Hendry, and St. Lucie counties. Our next presenter, Joseph Grant, an FSU and Florida Coastal School of Law grad with a range of experience. Joe was born in Brooklyn, but was raised locally in Juno Beach. Joe has a passion for mental health, fair housing, sustainable growth versus environmental impacts, and criminal justice reform. In law school, Joe won the National Animal Law Moot Court competition at Harvard University in 2010, was nominated for Best Oral Advocate, and received second place on his appellate brief. In his practice, he advocates for Legal Aid's Fair Housing Project and is involved in nonprofit First Accreditation Department, as well as having a small general practice. This is information on me, but suffice to say, I've been in fair housing for many years. I've been here at Legal Aid for over 21 years, serving in the capacity of doing education outreach, as you see on the screen, several different areas, and with a passion to fight for individual rights under the Fair Housing Act. Next, we have Takesha Miles, a graduate of the University of South Florida with a BA in political science. Takesha received her Juris Doctor degree from Florida State University College of Law in May 2003. After graduation, Takesha went to work for Florida Rural Legal Services as a staff attorney for 3 years. She began working for the Legal Aid Society in Palm Beach County in March 2006. She currently serves as the supervising attorney of Legal Aid in several different projects: elder law, consumer advocacy, veterans advocacy, and community economic development projects, neighborhood entrepreneurial project, and the Fair Housing Project. She investigates and litigates claims of discrimination against housing providers in Palm Beach County, Florida, and provides legal representation and counseling to seniors in the area of consumer, estate planning, guardianship, and real property law. Takesha has worked in the community with many wonderful organizations for a number of years. She currently serves on the board of directors for the South Florida Regional Planning Council's Revolving Loan Fund, and Southeast Florida Community Development Fund Incorporated. She is the former co-chair of the Palm Beach County Bar Association's Elder Affairs Committee. She is a past president of the F. Malcolm Cunningham Senior Bar Association. She is a current member of the board of directors for Adopt a Family of the Palm Beaches and has served as past president of the board. Takesha is an active member of Mount Hermon AME Church in Fort Lauderdale. And just to go in a little more detail about legal aid, again, as you see on the screen, the services that we provide, the areas that are of our general focus. You see elder, health, individual rights, children's advocacy, and family advocacy. We are constantly seeking opportunity to expand our services and to reach as many folks as we can out in the community. The Legal Aid Society of Palm Beach County is committed to providing high quality legal advice, representation, and education to the disadvantaged of Palm Beach County in order to protect their personal safety, enhance their opportunities and living conditions, and promote self-sufficiency. Okay, now we're going to move on to our first presenter, which will be Mrs. Guerrier from the Palm Beach County Office of Equal Opportunity.
Good morning. Since we've been sitting here, we have acquired 200,000 more residents. So the actual residents for Palm Beach County is 1.5 million. I need to update that information. Thank you so much to the Legal Aid Society for inviting me to participate in their Fair Housing Month activities. Fair Housing Month is a great celebration of the great work that a lot of our forefathers had worked on to make sure that individuals live in housing free of discrimination. All right, Carlton, are you gonna move the slides forward or am I?
I can do it if you like. Just let me know.
Okay. So today you're going to learn about the Federal Fair Housing Act, otherwise known as the FHA, Palm Beach County's Fair Housing and Places of Public Accommodation Ordinance, and the Palm Beach County Office of Equal Opportunity, otherwise known as the OEO. Next slide. Federal Fair Housing Act was passed in 1968. It was a tribute to Dr. Martin Luther King's work on advancing fair housing. He believed that with fair housing, everything else would fall into place so that where you live determine what type of jobs you would have, where you would work. Where you live would determine what type of places of public accommodation you would go to. So for example, restaurants, gas stations, schools. So he believed housing was integrated, everything else would fall into place. So as a tribute to him, the president at the time, President Johnson, signed into law the Federal Fair Housing Act in 1968 on April 11th, which was a week to the day of the Fair Housing Act. Prohibits discrimination on 7 protected classes: race, color, sex, national origin, religion, disability, and familial status. When it was passed in 1968, there was only 5 protected classes: race, color, sex, national origin, and religion. The act was amended in 1988 to add familial status and disability. So that meant from 1968 to 1988, it was legal to discriminate against individuals who had children, who were pregnant, or who were obtaining guardianship of children under the age of 18, and those with disabilities. Next slide. In addition to the explicit protected classes, as indicated, there was a decision recently. The court decided that sexual orientation and gender identity expression would be included in protection under sex. So while sexual orientation and gender identity is not explicitly listed as a protected class, individuals get coverage under sex. Next slide. Does the Fair Housing Act apply? It applies to all dwellings, residential dwellings, and that includes private, that includes public housing. We typically get questions or comments that, oh, I don't live in public housing, so this doesn't apply to me. And I have to remind them that it's any residential housing. It includes mobile homes, it includes condominiums, it includes homeowners associations. So anywhere where someone lives. And as you can see, the dwelling is defined as any building, structure, or portion thereof that is occupied as or designed or intended for occupancy as a residence by one or more families. We had cases that included university student housing, so that is also included. How is the Fair Housing Act enforced? It's enforced in the courts and it's enforced administratively. In the courts, it could be filed by individuals and it can also be filed by the government. Administratively, individuals can file complaints with the United States Department of Housing and Urban Development, who has the enforcement capability under the Fair Housing Act. And it can also be enforced by state governments and local governments. In Florida, the state government that enforces the Florida Fair Housing Act is the Florida Commission on Human Relations. And here in Palm Beach County, it is enforced by the Palm Beach County Office of Equal Opportunity, my office. The county also has their own ordinance, which I'll talk about later. Next slide. There are different theories of discrimination. The most that people are aware of, the first one is disparate treatment. And that is specifically treating someone differently because that person is a member of a protected class. Once again, the protected class under the federal law is race, color, sex, national origin, religion, disability, and familial status. Some examples of disparate treatment is that how a landlord would refuse to rent to a family because of that family's race, or a landlord refuses to rent to a family because there are children. Or a real estate agent only shows prospective national origin home buyers homes in a specific neighborhood because they believe that that family would be more comfortable in that specific neighborhood. Next slide. In addition to those examples, the way that a person can prove that they were discriminated against under the disparate treatment theory is by direct evidence of discrimination or demonstrating a prima facie case of discrimination, so circumstantial evidence. If a person shows that they have a prima facie case, then the burden shifts over to the housing provider and they have to provide a legitimate non-discriminatory reason for the action that they took. If the defendant or housing provider is able to do so, then the burden shifts back over to the plaintiff and they have to show that the reason that the housing provider provided was pretextual and the real reason is. Next slide. Another theory of discrimination is disparate impact or effect. It does not require demonstration of discriminatory intent as the disparate treatment case does. So when you look at a disparate impact case, it means that there is some policy, practice, or procedure that while it's neutral on its face, has a disparate impact on a protected class. Next slide. When we talk about the local agency that has their own fair housing ordinance, you're looking at the Palm Beach County Office of Equal Opportunity, who enforces the county's fair housing ordinance. So if you look online for something that says fair housing ordinance, you're not going to find it for Palm Beach County. What you're going to find is the housing in places of public accommodation ordinance. And in that ordinance, it has the same protected classes as the Federal Fair Housing Act, those same 7 that I talked to you about earlier. But in addition to those 7, the county also has sexual orientation, age, marital status, and gender identity or expression as protected classes. We are small but mighty. As Carlton mentioned before, the total number of staff persons in Palm Beach County Office of Equal Opportunity is a total of 12. So there's the director, a manager. We have 5 investigators. We have 2 equal opportunity specialists. We have a disability accessibility specialist, administrative assistant, and administrative technician. Small but mighty, 1.5 million residents in Palm Beach County. And we cover from Tequesta straight down to Boca, the town of Palm Beach, right over to the Glades, all of Palm Beach County. Next slide. In addition to our office staff, we also have the Fair Housing Board, which is comprised of 9 individual citizens that are appointed by the Board of County Commissioners. 7 of those board members are each appointed by a Board of County Commissioner, and then 2 are at large. And I believe we have one of our Fair Housing Board members who's participating in this training today. Next slide. So as I indicated before, the United States Department of Housing and Urban Development, HUD, enforces the Federal Fair Housing Act, and the Florida Commission on Human Relations enforces the Florida Civil Rights Act, and the Palm Beach County Office of Equal Opportunity enforces the county's Fair Housing Ordinance. Have a county ordinance that is what's called substantially equivalent. And what that means is that HUD has deemed the county's ordinance as equal to the Federal Fair Housing Act, such that the type of ways that we investigate our cases, the types of remedies that we provide, and coverage is similar to the Federal Fair Housing Act. And so they have entered into a contract with the county so that we are able to investigate cases under the Federal Fair Housing Act as well as the county's ordinance. In addition to our office, we also have 2 local fair housing agencies that are private enforcement agencies. The Legal Aid Society of Palm Beach County is one of them, and the Fair Housing Center of the Greater Palm Beach is another. Those 2 organizations are what's called Fips, Fair Housing Initiative Programs. And those organizations are different than our office because those organizations act as advocates. And I'm sure they'll go into more specifically about their role as an advocacy organization. Those organizations can file cases with our office, and we would investigate those cases. Next slide. So I talked to you before about the protected classes, and this slide talks about who can have a fair housing complaint filed against them. If it looks like everyone, it is everyone. Anyone that is involved in the residential home transaction can be a potential defendant, someone who can have a complaint filed against them. Apartments, newspapers, yes, even newspapers where they publish information showing that there's a preference for or limitation on the basis of a protected class. Real estate companies, realtors, banks, we talk about predatory loans, insurance companies, because you cannot get a mortgage unless you have insurance. And so if insurance companies are discriminated against individuals, they also are part of the problem in combating discrimination. Municipal zoning officials, city council members, condominium association, co-ops, neighborhood organizations, those individuals who don't want certain residential buildings going up in their area because of a protected class, housing finance agencies, state licensing authorities. So once again, anyone that is involved in that residential home buying or home renting process can be a potential defendant. Next slide. When our office investigates the complaints that are filed with us, we investigate under the county's ordinance. If the case has protection under the Federal Fair Housing Act, we dual file those cases with the United States Department of Housing and Urban Development, HUD. Once again, our office has a contract with HUD, and we have a contract through what's called a FAP program, which is a Fair Housing Assistance Program. Highlight to everyone that a person does not need to file a complaint in our office to enforce their fair housing rights. They can go straight to court. So it's like when you play Monopoly and you get that advance to go and you collect the $200, people can advance straight to court without stopping to file an administrative complaint. completely different than in an employment discrimination case. For employment discrimination, a person needs to file an administrative case before they can file directly in court, but not so in a fair housing case. They can go right to court. Next slide. So anyone who believes that they have been harmed by some type of action in the residential process, they can file a complaint with our office within 1 year of the last alleged discriminatory housing practice. So what does that mean? If they applied for housing within 1 year of that denial, if they were going through a purchase, same thing, within 1 year. The individual who files the complaint with our office is known as the complainant. They sign the complaint under the penalty of perjury that all the information is true and correct. Because what they're doing is they are stating that someone has violated their civil rights. And that is something huge to say that. So we want to make sure that they understand the gravity of what they have done, and we make them sign it under the penalty of perjury that all the information is true and correct. As we don't represent the person who's filing the complaint, nor the person who they're filing the complaint against, we provide the respondent with an opportunity to respond to the complaint, to give their side of the story. In our ordinance, it indicates that the respondent may submit a response within 10 days, and we tell them that they must preserve all records and any other evidence that may be relevant to the investigation. We also let the parties know that they may not retaliate against the complainant or any person that is participating in the investigation. And retaliation is when some action is taken against someone based upon either filing or participating in the investigation, or just even saying that they believe that they have been discriminated against in any words. They don't have to use those specific words. They can say that they believe that they have been treated differently, and then someone takes an action against them in that housing arena. They are protected under anti-retaliation laws. Next slide. When we investigate the complaint, what we're trying to do is investigate the case within 100 days. And you see that it's really a fast track. Once the respondent receives that complaint, once again, we tell them they have 10 days. And this is the reason why, because we have a short period of time to investigate the case. We have 100 days as indicated in our ordinance and as indicated in the federal statute. When we are investigating it, we need the cooperation of the complainant, because they are the ones that are stating that they have been discriminated against. And so if they fail to provide the requested information for us to complete a thorough investigation, we have the authority to dismiss that complaint. We also have the authority to enter on the property and review records from the respondent. We have that authority through our ordinance, and we can utilize subpoena power in order to do that if the respondent does not do so voluntarily. So we can take the testimony of individuals, we can put people under oath, we can review documents, and we can do site visits. Next slide. If someone has just received a fair housing complaint, they get very nervous. We're the government and we're here to help. Once again, we do not represent the complainant and we do not represent the respondent. What we do is we want to see if there has been a violation of the ordinance that we have the authority to enforce. Follow similar procedures for investigating the case as HUD, and that's why the HUD has deemed our office and the statute similarly situated to the Federal Fair Housing Act and how HUD does their investigations. We gather documents, we interview witnesses, and we conduct on-site visits as necessary. We provide the respondent once again with an opportunity to respond to the complaint, and we provide a summary of the respondent's response to the complainant so they know what the respondent's response is to the complaint. Once the investigation is completed, the investigator prepares a final investigative report, and I issue a determination on whether or not there's reasonable cause to believe that discrimination took place. If the investigation finds that there's insufficient evidence to support the allegations of discrimination, the case is closed with a no reasonable cause finding. If there is sufficient evidence to support that the allegations, there is reasonable cause to believe that discrimination took place, I will issue a reasonable cause determination. And we will work with the parties to try and resolve the issues that were noted in the complaint or that were discovered during the investigation. Parties are not able to resolve it in conciliation, then the case is usually referred to the county attorney's office and there is an administrative process. Next slide. When we talk about conciliation efforts, it's really just mediation. It's really trying to get the parties together to see if there is an opportunity to resolve the issues that were brought forth in the complaint. If parties are able to resolve it, the OEO drafts a conciliation agreement that is reviewed by both parties and agreed by both parties, and it's signed by both parties, as well as the director. Back and forth between the parties are confidential, and so that is not a public record. However, the final conciliation agreement that is signed by the parties becomes a public record and can be viewed by the public. When we are investigating a case, it is confidential, pursuant to Florida statute and the federal law. So if someone contacts our office to find out if we are investigating a specific case, we are not allowed to provide any information. We are not able to confirm or deny the existence of an investigation except to the parties themselves. Next slide. Once again, if the investigation does not conclude with a conciliation, I will issue either a reasonable cause determination or a no reasonable cause determination. If I issue a reasonable cause determination, once again, the parties have 30 days after I issue that determination to engage in conciliation efforts. If those are not successful, I issue a notice of failure of conciliation. And then upon the issuance of that, the parties are advised that either party can elect a civil action to bring a case in court, or the case moves to an administrative hearing before that fair housing board that I talked to you about. Next slide. So if a reasonable cause determination is found, once again, the complainant may have an administrative hearing before the fair housing board or elect a civil action. Next slide. If a no reasonable cause determination is found, then the complainant can still file a lawsuit in federal or state court, because remember, they did not need to stop into our office to file a complaint. So they don't need a cause determination to go to court. In addition to that, I need to make you aware that a person can file a case in court and can simultaneously file a case in our office. So they can have a case in court and have an administrative proceeding going at the same time. Not jurisdiction when a court case is moving forward. The only time the administrative process we lose jurisdiction is if there has been a determination on the case in court or the case has been submitted to a jury. Next slide. Various relief under the fair housing laws, as indicated, is actual damages, punitive damages, injunctive relief, and attorney's fees and costs. Same thing is found under the county's ordinance because we are substantially equivalent with the Federal Fair Housing Act. Next slide. I wanted to give you an idea of where we fall within the region for HUD, where Florida is. Title 8, once again, is the title of the Fair Housing Act. And in fiscal year 2021, this gives you a snapshot of all of the states that are within Region 4, which is the region in which Florida is in for its region. And as you can see, we have the largest number of cases in Florida, right? If you look at all 1, 2, 3, 4, 5, 6, 7, 8 states, we are the highest number of cases that are filed. Next slide. I also wanted to give you an idea, same snapshot, Region 4 is the region where those 8 states that I just showed you, where Florida is part of, and then nationwide. It cut off down at the bottom, but the complaints by basis in fiscal year 2021, what's in green is disability. So the highest number of complaints that were filed in fiscal year 2021 is on the basis of disability. Next slide. I wanted to give you a snapshot just of the Office of Equal Opportunity. And as you can see, we're going along just as in Region 4, as well as nationwide, which shows that the highest number of cases, complaints that are filed in our office are on the basis of disability. Next slide. Also wanted to give you an idea of the types of issues that come up in fair housing cases. So what are there? Refusal to rent, sell, falsely deny housing was available, discriminate in the terms or conditions of the sale or rental or occupancy of services or facilities. So what that means is that there are different terms or conditions that are provided to an individual that's different from someone else on the basis of, once again, race, color, sex, national origin, religion, disability, familial status, sexual orientation, age, marital status, and gender identity or expression. Advertising in a discriminatory way. Engage in blockbusting, discriminate in financing, broker services, retaliation, coercion, or intimidating someone who is exercising their fair housing rights. Sexual harassment, denial of a reasonable accommodation, denial of a reasonable modification, accessibility issues, otherwise deny or make housing unavailable, non-compliance with design and construction, because as you know, the Fair Housing Act was passed in 1968. It was amended in 1988 to add disability as a protected class. And so any residential housing where a certificate of occupancy was issued as of March 13, 1991, there are certain accessibility requirements. So we look for that when we're investigating cases as well. Failure to meet senior housing exemption. So as you know, the number one basis for complaints is disability. So I just wanted to give you once again an idea of what that looks like in terms of the population of the United States. 61 million adults in the United States lives with a disability. Okay, 26%, 1 in 4 of us in the United States have some type of disability. Next slide. The different types of disability, how a person is substantially limited, mobility, cognitive issues, independent living, hearing, vision, self-care. Next slide. Who qualifies as a person with a disability? A person who has a substantial impairment, a mental or physical impairment, right? So seeing, walking, hearing, breathing, anyone who has a substantial impairment. One or more major life activities, someone who is regarded as having such an impairment, or someone who has a record of such an impairment, or someone who is associated with a person who has an impairment. Next slide. Next slide. So I wanted to spend a little bit of time. I think, what do I have, about 8 minutes left, Carlton? Reasonable accommodations and modifications. Next slide. So a request for a reasonable accommodation is a request where someone is asking for a change in a policy, practice, or service, right? So someone with a disability, once again, a person who has a mental or physical impairment, they're asking for an exception to a policy, program, or service that will allow that person with the disability to be able to use and enjoy the dwelling, including any public and common use areas. In contrast, a request for a reasonable modification is asking for a physical change made to that person's living space or the common areas of a community, which is necessary for that resident to be able to have full enjoyment of the housing. So for example, that would be the typical examples of adding a grab bar in the bathroom, lowering closet rods, or installation of a ramp. Next slide. So how do you know if an accommodation or modification is needed? You know when someone asks you, right? Someone has to make that request. And how do you know that a person has a disability? Next slide. When a person has a disability, excuse me, I look at 3 different scenarios. Scenario 1 for me is that a person has an impairment that is obvious, and what they're asking for, there's a clear connection between their substantial impairment, and what they're asking for. In those areas, the housing provider doesn't need any additional information. They should automatically grant that request. And so an example of that is a person who has a visual impairment, and it's obvious that the person has a visual impairment and they've asked for, larger print. There is no additional information that is needed. The housing provider should grant that accommodation immediately. Next slide. Next slide. Next one is what I call scenario 2. So there is, you know what the disability is, the impairment. And I really don't like using the word disability because I think it confuses the housing provider. You know what the substantial impairment is, because just knowing the diagnosis, it does not tell you what the person's impairment is, how they are substantially limited in one or more major life functions. So once you understand what their substantial limitation is, but you don't understand what the connection is between what they're asking for and their substantial limitation, you only get to ask for the connection. So I see that you have a visual impairment, but why do you need someone to live with you? Okay, so you have to provide information to support why that person needs to live with you because of your visual impairment. One of the examples here is that the management knows a resident has seizures, but the resident wants to use an assistance dog. The housing provider should only provide a request that I need information to support why you need the dog based upon your seizures. Okay, next slide. This one is scenario 3, which is, I don't know what your substantial impairment is, and therefore I can't tell if there's a connection. So the provider is able to ask for information on the substantial impairment and the connection between the substantial impairment and what they're asking for. Example of that is someone with no obvious disability who asks for an accessible parking space. The housing provider can request verification both that the person has an impairment and the disability-related need for that parking space. Next slide. Next slide. So a housing provider must provide a requested accommodation unless the provider shows that there was no request, there's no disability need for the accommodation, or that the request is not reasonable. That means that it would impose an undue financial and administrative burden or would fundamentally alter the nature of the provider's operation. Next slide. Once again, a reasonable modification is a physical change. So the person is asking to change something physical in either their specific unit or in a common area. And that request, just like a request for a reasonable accommodation, can come at any time. Sometimes we have respondents, condo associations will say, well, they knew they were living up in the second floor. Why do they all of a sudden need to move down to a first floor? Or why do they need to put in an elevator? A person can become disabled at any time. As you saw, 61 million adults in the United States suffer from some disability. It can happen at any time. It can happen when they're midway in their living there. It can happen at the time when the association sends them a notice. It can happen at the time when they're about to be evicted. It can happen at any time, and a person is entitled to request an accommodation and a modification at any point in their tenancy. Next slide. Next slide. Next slide. Housing providers should evaluate each request on a case-by-case basis. No two cases are the same. So if a housing provider had someone who needed an assistance animal for one specific impairment, but someone has asked for something different, the housing provider has to look at that individual person and evaluate that specific person. Next slide. Who decides? The person with the disability, the person with the impairment. They know what is best for their impairment. Next slide. Interactive process is important and is required. If the initial request is denied, the provider must engage in an interactive process. It's that back and forth. It's sort of like a tennis court, is the way that we normally describe it. I know you've asked for this, but we can't do this. And the ball is back into the complainant's court. I know that you're asking me to do this, but because of my impairment, it's harder to do this. Can we do this? So it's an interactive process where the complainant and the respondent are having some type of dialogue. But if there's no resolution, it will be treated as a denial of the original reasonable accommodation request. The resident does not have to accept any alternative accommodation. It has to be acceptable to the resident. Next slide. This is a slide that has additional information where you can find on disability rights and responsibilities. HUD has some wonderful guidance, both for individuals with disabilities and also for housing providers. We typically will provide this information to both parties so they understand what their rights and responsibilities are under the law, and they understand the guidance for which we are investigating our case. Next slide. Emotional support and assistant animals, they are not pets, and they should not be treated like pets when it comes down to a request for an accommodation. No security deposits, no insurance, no breed restrictions. Next slide. Assistance animals may provide work, provide assistance, perform tasks, or provide emotional support. And completely different from the ADA, the Fair Housing Act does not have a specific definition of what type of animal. Whereas under the ADA, it would be a dog or a miniature horse. Under the Fair Housing Act, it's fair game, no pun intended. It could be a cat, it could be a gerbil, it could be a snake, it could be so many different things. Okay, so HUD has come out with some great guidance in January of 2020 that talks about and how to guide a request for a reasonable accommodation for an animal, and it has a specific section on unique animals as well. So it's a great guidance for you to have. Next slide, and I think that's the guidance. Next slide. I talked to you about that. Next slide. Next one. Talked about you can't deny a specific dog breed. Next slide. No breed restrictions by insurance. Okay, even if there is a local statute that has a breed restriction, federal law trumps that. Next slide. Thank you so much. I'll be here to take questions at the end.
Thank you so much, ma'am, for that very extensive overview of the Fair Housing Act, fair housing laws. Very helpful, very helpful. Next, we're going to move on to Joseph Grant and Anita Jones. Cover the attorney's role in the administrative process. Who's up first?
Carlton, I think that would be me, but Danita's going to join me as well. So first off, thanks everybody for joining us today here on Zoom to learn about this. So as Ms. Guerrier said, there's the FIP and the FAP. So one is assigned or delegated the duty from HUD to be more of the kind of the investigator, and we are the advocate, as she said. So this is our role in that process. I'm going to talk a little bit about investigation and actions, kind of pre-suit litigation strategies, tactics, best practices, and then Ms. Jones is going to move into more along the lines of what you need to prove in court if you can't get it done before you get there. So you can go ahead and move to the next slide, Carlton. Okay, so the pros and cons of using the administrative process. There's no filing fees. Obviously, everyone knows circuit court. I think they just changed them this last year, but it's like $400 to file an action. You have to serve the person, all that stuff. Then pay for the summons, all of those things. So there's none there. The OEO and HUD has subpoena power, which means if the investigation calls for the testimony of others, that they can subpoena records and people. The final investigative report at the conclusion of the case, So as Ms. Jones will tell you at the end, if you get especially if you get a cause hearing or a cause letter, that you'll have access to all of their findings. And there are some questions. Some courts defer to almost like Chevron deference a little bit, the test on whether an administrative thing is it's an administrative duty or if it's something in the court. A lot of times courts will defer to the agency that's delegated with this duty and their findings. So you can a lot of times get those findings will be admissible in court. So opportunity to settle the case. I think the latest statistics I heard, which more were not really from me, it was from a judge saying, I think if somebody was trying to delay the trial and he said 97 or 93% of these don't go to trial. So, this gives you that opportunity to do that without having to go through discovery, without having, I think Anita will talk about it later. But there's not reciprocal attorney's fees. There's an attorney fee provision. If the petitioner prevails, they get attorney's fees. It's not the same. It's not reciprocal. There has to be a finding that there was no valid basis for the complaint for a respondent to get those same fees. And also being able to get damages for clients as well. So there's plenty of settlements. If HUD usually post those. If you go to their website, you can see damages that are paid as part of settlements in fair housing cases. So you can go to the next slide, Carl. Thank you. So I guess I think that was back one. All right. So first principles, get it down to what to do, what you're doing and why you're doing it. So why was the Fair Housing Act created? Housing discrimination in the U.S. refers to the historical and current barriers, policies, and biases that prevent access to housing. So that's why we're all here working, at least if we work in this line of work, it's because these things exist. Housing discrimination became more pronounced after the abolition of slavery in 1865 as part of Jim Crow laws that were enforcing racial segregation. So a lot of Jim Crow laws are what was mentioned earlier. It's disparate impact. A poll tax on its face doesn't seem like it would be discriminatory, right? It's applied uniformly. It's everybody's got to pay it. But then if you look in the post-Reconstruction South, who were the people that couldn't afford to pay a poll tax? People who were just came out of being slaves. So they were disproportionately affected by that. And then it limited their voice. The same kind of thing can, in Florida anyway, can be said for voting rights after the non-restoration of civil rights after criminal convictions. But that's another CLE entirely. It was signed into law on April 11, 1968, which is an important week in that, a week prior to that date, Martin Luther King Jr. was assassinated. And it took really that kind of thing and the riots that happened after that for President Johnson to have the political clout, especially in the Senate, to get this bill passed because of I think they called them blue dog Democrats that were blocking the legislation in the South. And it allowed that to finally get passed. And the Fair Housing Act was created to address and remedy housing discrimination. And we're going to talk a little bit about how, that occurs. So you can go to the next one. So this is a quote from Mr. Coates from The Atlantic in May 1st of 2014. It's, if you sought to advantage one group of Americans and disadvantage another, you could scarcely choose a more graceful method than housing discrimination. Housing determines access to transportation, green spaces, decent food, decent schools, decent food, decent jobs, and decent services. Housing affects your chances of being robbed and shot, as well as your chances of being stopped and frisked. And housing discrimination is as quiet as it is deadly. It can be pursued through violence and terrorism, but it doesn't need it. Housing discrimination is hard to detect, hard to prove, and hard to prosecute. So that's why we pay so much attention to it. So, what is our role at Legal Aid? The Office of Equal Opportunity, which was just presented to you, is a FAP. We're a FIP. They investigate, we advocate. We are the Fair Housing Initiative program. Fair housing organizations and other nonprofits that receive funding through Fair Housing Initiative programs assist people who believe they have been victims of housing discrimination. So we need to look through that lens. The Office of Equal Opportunity goes from a petitioner, gets their statement, gets a response from the respondent, and then goes back and forth and evaluates those statements, vets them, sees what is occurring, sees if the parties want to consolidate. That is not, while settlement or a decision is what we're after, we're also here to advocate for a client's position. So we have a little more, I wouldn't say focused, but the petitioner, we're more focused on the petitioner. So you can go ahead and go. So first things first, listen and learn. So when the person comes in, and I do, or Anita does, or anybody in the Fair Housing Department does, a lot, you just listen and you try to hear what is happening in the case. I think I know myself, I can be guilty of a lot of times stopping short of, I know what this is about. I can, we don't have to say anymore. And I find myself doing that a lot, and that's something I need to address. But if I really want to be an advocate, I need to know what's going on. So try to get the whole depth and breadth of their experience and see, with my knowledge and others' knowledge of the Fair Housing Act, are they in a protected class? Is this something that's directly in a response to it? Is it something, disparate treatment? Is it something that only affects a class of such as this, disparate impact? Is this person disabled? Does the disability need the thing that they're asking? Is it reasonable? There's a whole bunch of questions, and I can not know the answers to those unless I listen to the person who's trying to give me the information. So you can go to the next one. So I'm going to give, in these, just a few examples. So a live-in caregiver. If no one's heard of one, it's, you have a disabled person or an elderly person who cannot do a lot of functions without their own. And we run into this problem a lot in this area because we have 55 and over communities, which are age restricted communities. So if someone's under 55, they're not supposed to be living there. As was discussed earlier, a reasonable accommodation is a change in a policy or procedure that is needed so that's to address someone's disability needs. So, in law, we define things, right? So first off, what's the protected class here? It's disability, which was added after the original ones. And how do you facilitate or advocate for that? You request a reasonable accommodation. Then you have to see, well, what's the definition of disability in the Fair Housing Act? And they do define it. And it's defined as a physical or mental impairment that substantially limits one or more major life activities. So you have to see, you have to listen to what they're saying. What do they need? Is this something that's related to it? All those kinds of things. And you can go to the next slide, Carl. So as we all probably can see, I'm sorry, I might sneeze. The law doesn't always, and statutes don't always define the words. They're written by legislators, and why maybe in Congress, in the federal level, maybe a predominant amount of legislators are lawyers. On the state level and in the implementation, not everybody is. So sometimes words aren't defined, and then we have to go back to, well, caregiver. What is a caregiver? There's no definition in HUD. However, HUD subsidized housing, which was mentioned earlier, does define. And it defines a caregiver as a person who is essential to care and well-being of the other person, is not obligated to support the person with the disability, and would not be living in the unit except to provide the necessary support services. So when does this happen? most of the time you're going to be dealing with live-in caregivers that are probably relatives. So that's going to be, as an advocate, we say, where do the facts are? When did they move in? What are the circumstances around when they move in? When was the accommodation made? Where's those? So these are facts that we gather. However, that is only, as an advocate, that's only subsidized housing. There's no but for those things happening in HUD related. So I need to look at the totality of the circumstances and see, is it reasonable? It's in the title, as some people say, is what I'm asking reasonable? And go through those checklists. And how do I do that? I listen, I gather facts, I draft a letter, I send it out to an HOA and put a housing person on notice. And then, most of the time the HOAs are going to have counsel. So then I'm going to start talking to an opposing counsel. It's a little different, than a little more, at least I try to make it a little more, where there's a little more disclosure than you would in a typical, you can get that through discovery kind of response. We're trying to, in this case, protect someone's housing rights. So you make a plan, you gather the facts that you'll need to prove it. Like what I said before, you create a list of persons that will need to be interviewed. So when do they move in? Is a neighbor going to testify? You need their old lease for the caregiver. You're going to need some kind of, while you don't need to provide a, because of privacy rights when it has to do with health things, you just have to have someone who can independently verify, and that can be relied upon. So a doctor saying that they need this kind of, the caregiver is traditionally enough. They don't have to know that the person has multiple sclerosis. I mean, that's invading someone's privacy and having to disclose that just to get a basic right. The federal government has said we all enjoy. To create a list of the documents that and records that need to be obtained, and then go after them. There's plenty of things, that with 55 and over communities, they have to do surveys. Did they do the surveys? If they didn't do the surveys, they're not complying with the rules regarding that, and therefore they can't deny people that are under 55. I would argue, as an advocate, so just certain things, and you'll need an expert to prove elements. Are you going to need an expert? And the change in the expert rules and laws in Florida in the last couple of years, you're going to brush up on that. What do you need to prove? The building things. So if it's built past a certain year, there's certain requirements that it already has to have. So you can say, oh, well, this, if there's a regulation that it needed to be updated during when they pulled a certain permit and they didn't do it, therefore a disabled person can't use it. Therefore, it's a violative. It's violative of the Fair Housing Act. So you can probably move to the next one, Carl. Okay, another example: selective enforcement, disparate treatment. How the act applies. Listen to potential clients' concerns. What is happening? What are the actions that are taking place? Remember, again, I say it over and over. I really like being an advocate. Maybe it's something about law school, it's something about that drew me to this profession. I don't know. But we are the agent of the person, and we're seeking to enforce their rights under federal, state law, local ordinance, all that stuff. You can go to the next one. Use of code. So this is another disparate treatment, use of code enforcement. Is there a similar practice of enforcement in other local neighborhoods? If not, why? Why are the actions taking place? Request ordinance violation records. These are all things that you can do. There's plenty. I think I'll talk about this a little bit, but there's plenty of cases that have to do with selective enforcement based on ordinance things, which is using a code violation as a tool to get people to move. So there's also the eviction process, the CARES Act. Why is the landlord accepting funds why are they or aren't they accepting them for all the residents? And then you look at, is there a difference between the two residents that they are and are not? What's the end result? And an action you can take is also, we have a department here where we can send a tester, and we can send someone who, you know, maybe has an accent of some sort, and or speaks a different language, and asks if they have someone over there that speaks another language, and if they're treated in a different way, and we already have evidence that those people are treated, or the people in that class are treated separately and differently in the underlying case, well, that's something that can be used later. You can go to the next one. So developing an investigation plan, public records requests, code enforcement, building and zoning departments. Building and zoning departments, Florida Commission on Human Relations, Florida Department of Business and Professional Regulation, realtor complaints and records. There's plenty of those that we've had to do where testers have been involved, and you know, using, for example, criminal background checks. If it's a blanket background check, HUD's and it's used to prohibit anyone with a criminal record, that HUD said that that's discriminatory. There's no valid basis on why a drug charge, that a non-violent drug charge, would have anything to do with somebody's housing that happened 20 years ago. If you have something like a violent, arrest or a conviction, a violent act, yeah, then that is something. But just saying that, you know, any criminal violation or any criminal blip on a background check is discriminatory, and that guidance is directly from HUD, and they base that on statistical analysis across the United States. The office of the Florida governor, complaints regarding notaries and things of that nature. Review and preserve website data, review court dockets. That'll come up in a case that I'm going to speak about in a couple minutes. Review local property appraiser records online to confirm ownership and numbers of properties involved. And finally, review community association websites. So this is a big one, like where they'll have some, they won't be compliant, and it's on its face, it's like patently violative of the act, and then, you know, they're basically just transmitting that on the web, and those kinds of things can be other evidence of fair housing violations. You can go to the next one. You can use other databases, LexisNexis or Westlaw, as you know, a lot of things you can find on there. Asset searches. You can go to the next one. And here's another example of a sober home case that I had, and it was disparate impact. How does the act apply? Individuals not currently drinking alcohol or using drugs and having a history of drug and alcohol abuse are considered disabled. So if they're in recovery, they're considered to have a disability. So what was happening in this case was the landlord was, there was a current suit for a breach of contract. The tenant was a sober home treatment facility, and they had subtenants. And as part of that, there was a concrete restoration project that had a very, the original declaration by the landlord was that it would be a short construction project, you know, I think 2 months they called it chipping when it was in actuality a jackhammer. And 9 or 10 months later, they're still in the middle of it. And, you know, the people, you know, that it was affecting a person, like a whole group of people in a protected class. This landlord and tenant situation had rented out 2 buildings that were only used for that. So the impact to the people that were in a protected class, I thought, was clear. You can go to the next slide. And so how to advocate for that person. So what to do there? You know, we filed OEO complaints. And then there was an independent action brought by the landlord in circuit court. And we joined in that and joined in litigation efforts to try to come to a resolution. And it was just negotiated after that. So you can go to the next one. So this one is, as you probably look around Palm Beach County, there is a lot of issues with housing right now. And especially with, rent increases. I think the last things I saw were like 38% increases in rent across the board. And this is really affecting renters in the county. What it's done in certain circumstances is housing prices are soaring, and which is having a lot of people come in and try to swoop in, and much like in 2008, but in a different way, when the housing prices were going up, the HOAs were trying to do condo conversions. So it went from apartments to when those prices. Now, well, I've seen a couple times where they've come in and tried to buy all up and dissolve the association and then turn it back into an apartment complex. So, housing, owning a home provides for wealth building, generational wealth. It's usually the largest asset that somebody has. And you can go to the next slide, Carl. And why does the act apply here? Courts that have found that discrimination need not be the intent of the adverse party in this. So this is disparate impact. So what's happening in this situation is every owner that is left in the association, besides the mass owner, is a person that is protected by is in a protected class. So what's the most likely intent of the owner coming in is probably money. But again, in this circumstance, the only people being affected by the changes which are being done, to the governing documents to devalue the property, the assessments that are being taken, the non-notice of meetings, all of those things we believe are being used to basically make the people in the protected class, their property worthless, so that they can come in, purchase it, and then rent it out at an exorbitant, maybe not exorbitant, but at a retail price where they get all of the benefit of that. And then a lot of people in a protected class just got their biggest asset taken from them. So how to advocate in this? You get the governing documents. When were these amendments made? How are they noticed? What kinds of documentation do they have? Are the fees related to the fees that were charged? Was everybody charged the same fee? Was there a restriction on sale or a price that needed to be paid? Like all of these things, look for selective enforcement. Who is making the board decisions? All those things are types of things that you would look when you're investigating these kinds of things to see, to try to build the case. You can go to the next slide. So what to do next? What are our goals? Our goals are to, first off, we got to talk to the client, right? Like we want to protect fair housing, but we also need to know what that means to the client. So we need to talk to them. What furthers fair housing rights? Do the client's goals and the goals of furthering fair housing coincide? And maybe if they don't directly, like how to facilitate that? Like, do we get people in and, as part of a lot of settlement agreements, we have training. If there's a conciliation, the person or HOA or whatever, the respondent has to come in for fair housing training to learn about the Fair Housing Act, and to hopefully make sure that at least they're aware that, and it won't happen in the future. So how to facilitate that outcome? Communication. I think if you look at maybe not hopefully, but I'm sure there's a lot of attorneys on this training. If you look at the disbarments usually have to do with commingling of funds, but a lot of bar complaints that end with anything have to do with not communication with the client. So just make sure that you're trying to communicate and figure out like these things, that you create a record of that communication. And to the opposing party in the council as well, and opposing counsel as well, to see if you can work together. As we said, there's a conciliation part of that. And determine how to get there. You file a notice of representation, send it. The reply and response to the opposing party. You can use the OEO complaint process to initiate things if maybe it's not getting as formal as you'd like as quickly. You can file a DEC action, declaratory judgment action, to have the court determine the contractual rights between the parties. You can file for a preliminary injunction if there's no adequate remedy at law, all those kinds of things, and try to get some action that way. You can file a complaint. There are some questions on the Florida statute. If it is invoked, sometimes it's interpreted that you're required to exhaust administrative remedies, much like a collective bargaining agreement, when you have to go through those kinds of things before you have the ability to file an action. But that's not required with the federal act. So, I think some people would say it's mandatory to go through the OEO process before you're able to bring a Fair Housing Act under Florida statute, but that's not the case with the federal statute. If there's a current action against your client, a lot of times this comes up lately in landlord-tenant issues, where maybe the eviction was filed in retaliation, and then you file a counterclaim and you say, this is what's happening. This violates the Landlord-Tenant Act. It violates the Fair Housing Act, and then you can start engaging in litigation that way. So those are all just some examples of how to proceed. You go to the next slide, Carl. Oh, and that brings me, it's time to litigate. If you can't get it through all that, and I'll turn it over to Anita Jones.
Awesome. Thank you. Thank you. Thank you. And good afternoon, everyone. So you have this discrimination case in front of you, and you've either gone through the administrative process, of which Ms. Guerriere spoke about, and or you have made the decision to file a suit or include a fair housing allegation in your answer as a counterclaim. In any case, it is time to litigate. So when we're choosing litigation, a fair housing claim may be argued on the defense if you are a defendant in the case, as Mr. Grant alluded to, or on the offense if you are the plaintiff. You will engage in the litigation process the same way that you do with any other case. But let's first start with speaking about the defense. So fair housing claims may be raised both as an affirmative defense and as a counterclaim. We see fair housing claims arising in responses to evictions, unlawful detainer actions, and ejectment actions. So as an example of how this can come up, hypothetically speaking, a potential client comes into your office seeking help because she refused to enter into a relationship with her landlord. And in the process, or in response to her non-acquiescence, the landlord starts sending threatening and harassing text messages and serving her with bogus notices of violation for a pet that he had previously approved to occupy the property. Additionally, he continuously demands that she leave the property and threaten to evict her. So this client's there, she's telling you about the discriminatory actions of her landlord, and you're discussing with her, hey, let's file an OEO complaint. These are your options. But just prior to sending the initial complaint over to OEO, alleging sex-based discrimination, boom, he serves her with a notice of non-payment of, he serves her with a complaint, an eviction for the violations of the pet. Now, in lieu of filing the complaint with the Office of Equal Opportunity as originally planned, you and your client, or your client decides that she wants to assert the Federal Fair Housing Act and local ordinance as an affirmative defense, and also add in a counterclaim in the case. In this case, what is helpful is that the affirmative defense for, hey, this eviction is not about me violating the pet policy because he actually allowed me to have the pet, but it's because my landlord or property manager is retaliating against me and harassing me. And those defenses to the evictions, that defense to an eviction can help, not only negate a claim, but also help with negotiating settlements and making sure that your client is not evicted. So that's an example of when you would raise a fair housing issue or claim in an affirmative defense. And then, of course, you can file a counterclaim as well. When we're looking on the offense or filing a fair housing claim, you want to consider jurisdiction, as Ms. Guerriere included in her presentation, and also Mr. Grant. You have the ability to file a fair housing claim in both federal and state courts. And just like with any case that you litigate, it is important to understand the relevant laws, the relevant facts applied to those laws, and also any nuances that they may entail. In doing this, the next slide, please, I have found that the memorandum issued by the United States Department of Housing and Urban Development in 2014 and subsequently revised in 2018 helpful. It provides the elements of proof that a complainant need to meet in order to be successful in their fair housing cases. Next slide. So Ms. Guerriere provided us with a number of reasons why one may file a fair housing complaint. When preparing a litigation case, these elements are extremely helpful in outlining how your client meets each of the elements. They are also extremely helpful in drafting jury instructions and, of course, presenting your case. Within the memorandum, you will see, as I have on the screen here, for instance, the claim that a housing provider has made housing unavailable. And if that is the case, and if the unavailability is due to one's protected class, it is actionable under the Fair Housing Act. For the sake of time, let's look at the refusal to rent or sell elements that I have here on the left side of the screen. And I'll give you an example of something where this may be applicable. So client, Ms. Jones, I'll use my last name for an example. Ms. Jones is disabled and searching for an apartment to rent. She sees an ad in the local paper advertising an apartment for rent. She inquires about the property, and the property manager basically tells her over the phone, you know what, you qualify. This apartment is for you. It is going to be yours. You just need to complete the application as, part of the process. Ms. Jones, who uses a wheelchair, completes the application, and she goes into the apartment complex to check on its status. When she goes in, she's notified that her application is rejected. No reasons were given for the rejection. So Ms. Jones believes that her application was rejected because the property manager saw that she was disabled. The unit is eventually rented 2 weeks later to a person who is not disabled. Does Ms. Jones have a basis for filing a fair housing complaint? I think that she does. If you look at the elements, Ms. Jones is, one, a member of a protected class. And I'd argue that to the judge or the jury in a trial. 2, she applied for and was qualified to rent the unit. The property manager told her that she was qualified to rent the unit, and there was no reasons as to why she was rejected. The complainant's application was rejected in this case after she arrived in her wheelchair. The property manager told her that her application was rejected. And in this case, the unit did remain available for 2 weeks later. And also it was rented to a person that was disabled. The interesting thing is it's either or, either the dwelling remained available thereafter, or the respondent rented or sold to a person that was not of the complainant's protected class. So we had both in my example, but that's an example of how you would determine whether you have a fair housing case, and essentially how you would frame up your argument for the jury or a judge. Next slide, please. we talked a lot about reasonable accommodations already. Here at Legal Aid, as Joe mentioned, we get a fair amount of cases where a client is seeking assistance with making a request for reasonable accommodation. Oftentimes, it's because they are asking for an emotional support animal in communities where there's a no pet policy. Again, as was stated previously, if the request is not unreasonable, it meets the 3 elements that are laid out here. And it's necessary to afford the complainant an equal opportunity to use and enjoy the dwelling, but the housing provider denies the request, then they are able, or a person is able to file a lawsuit or a complaint with the Office of Equal Opportunity. Next slide, please. So terms and conditions are covered under Section 804B, generally under the Fair Housing Act. But if the person is disabled, then it's covered under 804F2. Changes in terms and conditions in negotiating the sale or rental, or changes in terms during a tenancy based on a protected class, may also set a housing provider up for lawsuit. So in the case that I mentioned previously, where the landlord filed suit after the client refused to acquiesce to his sexual advances and refused to enter into a relationship with him, he changed the terms. He said, hey, I'm going to now file a violation because you have a pet. And that is a violation within itself of the Fair Housing Act. Because he had a pet, she had a pet, but for her not engaging in a relationship with him, or he would not have filed the eviction case against her. And the terms and conditions, we look at them during the tenancy as the example that I provided, as well as negotiating a sale or a rental as well. Next slide, please. It is a violation to make, print, or publish a notice, statement, or advertisement with respect to the sale or rental of a dwelling, in which indicates a preference, limitation, or discrimination based on a protected class. So let's look at the example here. This is an advertisement for a unit, a room. Of course, there are some exceptions or exemptions under the Fair Housing Act, but let's just generally speaking, absent any of the exceptions, I think that if you look closely at this advertisement, that the housing provider is essentially setting themselves up for discriminatory action to be filed against them. First and foremost, I mean, the preference of well, let me just go to the obvious here. They ask for the applicant to provide a brief description of themselves. And they ask for race, they ask about age, and also a picture. What are they going to use that information for? I don't know, but like I said, it could set them up for some sort of discriminatory lawsuit against them. It also asks, it also says pet-free home. And so, the question is whether this housing provider would refuse someone because they had an assisted, an emotional support animal or a service animal. But this would be an example of an ad that could be deemed discriminatory. Next slide, please. All right, so harassment generally fall under subsection 804B or section 818, but it may fall under other subsections of 804, including subsection 804A if the harassment resulted in the loss of housing. And I talked about, you look at the elements of proof, and this is also included in the elements of proof as well to determine that. Our office, well, let's see, there's essentially 4 different types of harassment. There's a hostile environment harassment. This is for any protected class. No matter what protected class someone is harassing you based on that protected class, it's actionable. There's also sexual harassment. One second here. Sexual harassment in creating a hostile environment. Sexual harassment quid pro quo. That's when a complainant acquiesces to the sexual harassment or sexual advances, but then once they stop, then the landlord, moves to evict them, for instance. And then the same thing for quid pro quo, that they're refusing to acquiesce to the sexual harassment or sexual advances. And as a result of that, they face some sort of discriminatory action by the housing provider or the landlord. I used landlord in the last example. Our office currently is representing a plaintiff whereby she filed suit against the property manager and the property owner alleging sexual harassment claims under the Fair Housing Act and state law. And in that case went all the way up to the 11th Circuit Court. And because the district court found that there was no guidance from the court on the question of whether her claims were actionable under the Fair Housing Act. In that case, the 11th Circuit held that sexual harassment, both hostile housing environment and quid pro quo sexual harassment, is actionable under the Fair Housing Act of 1968 and provided that the plaintiff could demonstrate that she would not have been harassed but for her sex. So that case is currently in litigation in the Southern District of Florida. We're interested to see the outcome of that one as well. Next slide. So we talked a little bit about, what happens once you receive a reasonable cause notice. I know Mr. Grant alluded to it a little bit. Next slide. Pro tip, the first thing that I would do is I would request a copy of the investigative file once the case is closed. These files will include witness statements, documents obtained during the investigation. The case that I'm working on right now has affidavits signed by party opponent. So it is quite interesting, a very, very good starting point. And it also helps you to start developing a case theory, a case theme. It helps you with deposing the witnesses in the case so that, because you already pretty much have an understanding of what they've told the OEO investigator. So now you can depose them and you can dig a little deeper. It has the documents. It is so much. It's convenient. Let's put it that way. It's convenient to get this information and have this information so that you know from the start how to go about attacking and litigating your case. Next slide. That investigative file, it's going to have, the complaint allegations, like I said, respondents, defenses, findings, and conclusions, the same thing, how you would, if you were going to go in and litigate a case. So again, as I think we've reiterated so many times during this webinar today, next slide, please. Your options, you have so many options. You can, if you get a reasonable cause finding, you can take another attempt to settle a case. You can go in and participate in an administrative hearing with the Fair Housing Board. You can sue in state court or you can sue in federal court. That is all I have for today. Thank Ms. Miles.
Yeah, thank you, Joe. Very well done. We're going to move on to our last presenter. It's Ms. Keisha Miles. She's going to.
Good afternoon, everyone. So I'm going to talk a little bit about ethics and give you some good tips on some resources if you find yourself in doing some litigation or either on the offense or defense of a fair housing claim. So first want to talk about, and this was mentioned before, when a client has a disability, sometimes you'll find that the respondent or the housing provider will allege that your client poses a direct threat. And so what that means is that under the Fair Housing Act, under 42 US Code, Section 3604, a tenant or individual who provides or poses a threat to the health and safety of other individuals, or where the individual poses a threat to cause damage to the property of others, they may be exempted from application of the Fair Housing Act. And so we want to know from the start that not everybody who has a mental disability or physical disability is going to be deemed a direct threat, and you should fight any kind of assumption that they are. But there are some times when you're going to have to really look into the client's medical history and kind of figure out, are there ways that we can use a reasonable accommodation to combat the allegation that they are a direct threat, and to ensure that their illness is not preventing them to be able to reasonably enjoy the premises. The other part of this inquiry is to think about, is the failure for the housing provider and their unreasonableness to grant the reasonable accommodation exacerbating the person's condition. So HUD has looked at regulations to require that the housing provider make an individualized assessment. We don't want to just say that if someone has bipolar, they're going to be a direct threat. Person has schizophrenia, direct threat. Absolutely not. We're going to have to do an inquiry to make sure that, is the person a danger or a threat to someone else? And it can't be that I have a fear of someone. It has to be something that's a real live threat. And we always should be looking at their recent behavior. We can't say that because someone 20 years ago had something happen to them or they did something, that should be used against them today. We want to look at the level of dangerousness that they pose today. And if they're going to be using any conduct that has happened, that conduct has to be something that's recent. Next slide. So can a reasonable accommodation help the issue? And one of the examples I want to use is from a case that I had early in my career where I represented a elderly couple who had their 40-year-old son living with them in their unit. The son had bipolar disorder and would not always be medical and medicine compliant. And so he had been Baker acted a number of times during a period when he had gone off his meds. He attempted to stab his mother with a pencil. But what brought the issue to a head and made it an issue for the condo association is that they lived in a 55 and older community, and the son, in one of his moments of being off his meds, went to the balcony and started throwing soup cans and canned food off the 7th floor balcony. Now, ordinarily throwing canned food out your window would not cause you to be considered a direct threat. But the position that the association took was that throwing cans off the balcony at 7 stories up could cause serious harm to the other residents who might be walking on the sidewalk and in harm's way. So what we did in that case is that we tried to work on a reasonable accommodation. The initial reasonable accommodation that we requested was denied, and we made the association engage in an interactive process with us. The client's son did have to go get some treatment because of the illness. And so the family agreed to bar him from the property for 6 months. Then after the 6 months period, where he was allowed to come back for day visits. And then we worked an accommodation schedule where he can come in for visits, but not stay overnight, and then gradually get to having more of a relationship where he can come back on the property and continue to have that sense of familiarity with his family. Sometimes the reasonable accommodation may not help. Sometimes there may not be ways around it. We've had cases where our client has attacked individuals, the property manager, and unfortunately, sometimes when there's a criminal element or the client gets arrested, we try to connect that the person's disability with their conduct, but sometimes it is hard to overcome the direct threat element in the Fair Housing Act. Next slide.
Wow.
Okay, so the next part is just to kind of talk about some of the ethical considerations when you have a client that maybe has a mental health issue, maybe they are have an issue with hoarding, or when they have diminished capacity. In the work that I do at Legal Aid, I run our elder law program and fair housing program. So what you see on the slide, those three areas often collide with seniors who may be experiencing elements of diminished capacity due to dementia or Alzheimer's, clients who have some sort of mental health issue that's causing them to be a hoarder, and it's causing the housing provider to maybe writing them up for not having access to the ingress and egress for fire issues. Often we find out there's a hoarding issue when the tenant refuses to allow pest control in, or the housing provider to do inspections. And then, part of the reasonable accommodation process, modification process that all the presenters talked about is that we have clients that have mental health issues. And I would really encourage everyone who is listening today to try to do some basic research and have some basic information about some of the major disorders: bipolar, depression, anxiety, schizophrenia, just so you have a small framework of what the client is going through and how sometimes their symptoms manifest as they're going through their activities of daily living. And I think it helps you become a better advocate when you understand what might trigger them, some of the issues that might be a concern in the housing context, or it may be that how the property manager is speaking to someone that might be triggering them to have some sort of mental health issue. But when you get to that point and you have that client who maybe have diminished capacity or maybe under a disability, the Florida bar rules are on point. There's a Florida bar rule 4-1.14, and there's a corresponding ABA rule that deals with disability, clients with disability. And so our goal as lawyers is to ensure that we try to maintain the best that we can, a normal relationship with that client. If it gets to the point that we cannot maintain that normal relationship with the client, then we may have to appoint a guardian, or we have the cover of the regulation to get a guardian appointed, or someone to act in their best capacity. But we're going to presume that everyone is legally competent unless otherwise noted, and that we want to make sure that when you're dealing with a client under these circumstances, that they actually have the capacity to engage your services. Are they able to sign a retainer and be your client in that capacity? We want to make sure that we understand that when we're talking about these kind of clients, in this case, we're talking not that necessarily that someone of a certain age has a capacity issue. We cannot say that someone who's 98 years old is assumed to not have capacity. We're not going to assume that because the person may be suffering from a stroke and maybe has aphasia and has trouble speaking, doesn't have capacity. It is a mental determination. It's a mental capacity issue that we're looking at. And it's not really something I can just say it's black and white. You can't just say the person has schizophrenia, they automatically don't have capacity. It's really a spectrum of what someone may be going through. They may have a state of mind issue, that they have good days and bad days, and you might be able to work with them in that respect. But you want to make sure that the client can appreciate the consequences of their decision, and that you are able to make sure that they are understanding that what decisions that they're making and how those that could impact them further. And one of the other things that comes up, especially in the sense that we're representing clients with diminished capacity or with disabilities, mental disabilities, is that it becomes kind of gray area as to who is your client. The client may present to you through the care of a family member, a daughter, son, loved one who is trying to look out for that person's best interests. You might be contacted by the guardian, the caregiver, the power of attorney. We often have a lot of helpful neighbors that think that they're doing the right thing by trying to intercede on their behalf. And you want to be careful that you're acting on the interest of what the client is in the client's best interest, and not necessarily in the interest of the person that's bringing the person to your attention. So the final thing I want to do is talk about the resources that are available. So I know that Ms. Guerrier provided you with some additional resources, especially with the disability, but HUD and Department of Justice have a number of joint statements and policy guidance that are available on their website. And I want to point out a couple of them to you. The reasonable accommodation and modification memos are very helpful in just understanding the rights of a person with a disability and the limits of a housing provider. One of the oldies but goodies is the Keating memo on occupancy standards. Even though it says March 1991, it is still good guidance for us. So as you are dealing with housing providers that are saying that this family might be too big for their unit, or the HUD Keating memo goes through a different factors that you can we should use in determining how many people can limit a unit. So they're going to look at the parking spaces, the use of services, the spacing, the square footage of the unit. So it's not just as black and white that a housing provider will try to say it is. Next slide. So one of the best tools that I ever discovered as a young attorney was the Department of Justice's website. And so you can go on their website in the Civil Rights Division, and they have a listing of their housing cases. And if you're ever stuck in drafting a complaint, you can go and look at the Department of Justice complaints. They have them categorized by all the protected classes. You can click on it, you see a summary of the facts, you can look at the complaint and you can see how it's scheduled. I also find this website helpful to see how other cases have settled, what amounts. Sometimes it's kind of in coming up with damages, it's kind of the balls in the sky as to what you want, but you have to kind of figure out what is reasonable. And sometimes this website is helpful to go through and see what other clients have been awarded in a similar situated fair housing case, because sometimes you have to take that to your client, because your client may think that they have a $100,000 case when it may be a $5,000 case. And so sometimes it's helpful to show them with facts similar to yours, this is what has happened in a court of law or through some sort of conciliation process. So next is HUD's website. HUD has a lot of information if you're ever just looking for executive orders that might apply. All the different code of federal regulations that HUD enforces will all be listed here on their website. The National Fair Housing Training Academy is a wonderful resource for training. As you see, one of their upcoming events for May is a litigating fair housing case seminar. And so I would encourage you to go on, if you want to learn more about fair housing, to go on there and sign up for one of their trainings. And wouldn't be remiss without telling you about the National Fair Housing Alliance. They are a national organization that many of the fair housing organizations are a member of. But what's very helpful is they every year they survey the fair housing organizations like us and ask for data about the kind of cases we've been handling, any of our settlements that are reportable, and they compile them in the Fair Housing Trends report every year. This is another tool that's helpful to see what other case trends there are going on. You'll find other cases that have been litigated across the country, and you'll be able to see whether settlements are out there. Like I said, finding facts that are similar to yours to try to figure out what kind of damages that you should seek in your either conciliation or in your litigation. The National Fair Housing Alliance Fair Housing Trends Report and the DOJ website are very helpful in trying to craft what your damage claim will be. So I'll turn it back over to Carlton if there are any questions in the audience.
Thank you, Takesha. If you have any questions, if you would, please put them in the chat box, Q&A box. We have a few minutes left at the top of the hour. Okay, we do have a comment. Outstanding information and presentation. We do appreciate that. Anyone else? Okay, we have a question. Are landlords required to do reasonable modifications?
Pam, do you want to take that question?
So in terms of accessible housing, it had to have a certificate of occupancy issued as of March 13th, 1991. And it's for multifamily housing. It's not for single family housing. So in order for it to be in compliance with the accessibility guidelines established by the Federal Fair Housing Act, a certificate of occupancy issued as of March 13th, 1991, there are 7 different accessibility requirements that it needs to have. And provide that information if they need additional information on that.
And I would just add, if the property needs to be modified so that a person with a disability can have equal enjoyment, if it is a private landlord or housing provider, the landlord's not required to pay for that cost. If there is federal funding attached to that program, a public housing unit, or someone under the USDA regs, low income tax regs, they would be required to help cover the cost of the reasonable modification. But we, always encourage the parties to do a interactive process so that we can, get to a place where the modification can be granted so that everyone can be happy.
Okay, thank you. We have a question for Pam. What are some signs that a respondent Danita, you want to read that question? I apologize on the distance. I can't.
I can read it for you. I think the question is, what are some signs that a respondent is retaliating because of a fair housing claim has been filed against them? And what should a complainant do if they feel they are being retaliated against?
A complainant believes that they are being retaliated against, they would complete another questionnaire in our office for it to be evaluated. Once again, they don't initially have to have an existing case with our office. Retaliation is a standalone violation. So the only way that they would get protection is either they have voiced opposition to discrimination, say, I believe you've done this because I'm whatever, one of the protected classes. Or if they have filed a complaint of discrimination, or they have participated as a witness in a fair housing complaint investigation. So the first thing, once again, is to complete a questionnaire submitted to our office for evaluation. Actually, retaliation cases are very easy for us to determine, because what we're looking at is we're looking at the history. What's happened before the person engaged in the protected activity? What happened before they notified the association that they believe that they were being treated differently? I think, Ms. Jones, you alluded to a couple of different cases where a person was in a consensual relationship, or it might not have been a consensual relationship, and then they decided that they didn't want to have that relationship with the person. Then all of a sudden they're being treated differently. So they're opposing discrimination, and now there's different terms and conditions being put on that person. So those cases are really easy for us to investigate and issue a cause determination. And once again, we don't have to have a cause determination on the underlying issue. It's a standalone issue. So if we can find that they were retaliated against, we can issue a determination on that.
Thank you for that response. Takesha, can you please read that question? I can't see it.
Okay. So the next question is, although it obviously depends on each case, how long would a case typically take? Alluding to the interactive process for purposes of explaining this to a client and managing expectations. So cases, especially in the pre-litigation stage, if you're going through the administrative process, could take, up to 100 days. So we want to make sure that we manage expectations of clients that, especially, that they understand that if we're going the route of an administrative complaint, that we're on the timetable of the administrative agency. And they have their own timetables that they have to do for HUD and the regulations. But typically we want to let them know that it could take a minimum of 100 days to investigate and go through the administrative process. But if we are in our pre-administrative phase and we're trying to just work with the landlord or housing provider on a reasonable accommodation or modification, we will send the letter, gather the information to get the doctor to do a letter or medical team to do a letter, submit that to the housing authority or to a homeowners association. Sometimes we might hear back that the homeowners association or condo association only meets monthly. And so their attorney may say that it may take 30 days before that is heard at the next board meeting. So we just want to make sure the client understands that, unless it's something they immediately need, there may be some time to wait, but we want to make sure that they understand that we will pursue the issue if it seem like they're unduly delaying a response or unduly delaying responding to our request for accommodation or modification.
I would add is that as an administrative agency that follows HUD guidelines and our ordinance, our goal is to complete an investigation within 100 days. And if we're unable to complete it within 100 days, we are required to send a 100-day letter, which lets the parties know what we have left to complete and our anticipated date of completing it. So we are required to provide that 100-day notice.
Okay, there appears to be another question regarding retaliation. And so when we talk about retaliation with the Fair Housing Act, it's retaliation for them exercising their right under the Fair Housing Act. So we don't want anyone who has sought our services, has filed a complaint with HUD or the Office of Equal Opportunity or Florida Commission on Human Relations to be retaliated in any way. We don't want them to be non-renewed because they are exercising their rights. And so that's what we mean by retaliation under the Fair Housing Act.
The question, I believe, talks about for calling code compliance. And this kind of gets tricky because we would need more information. Why did you call code compliance or code enforcement? So if you're calling code enforcement because they are not maintaining the property and you believe they're not maintaining your property the way that they are maintaining another tenant's property, and it's one of those protected classes, then it would be discrimination. But just calling code compliance just because of regular run-of-the-mill issues with the property and having nothing to do with being treated differently because of your protected class, no, that is not a fair housing issue and that's not retaliation. I think there's another question about retaliation on non-renewals of lease.
So the next question says, does retaliation include non-renewals of leases with no cause shown where a tenant has a mental health disability and the prior eviction case was voluntarily dismissed? So, unfortunately here in Palm Beach County, there's no requirement to tell us why a landlord is non-renewing their lease. There are some local municipalities and counties where they're required to give notices and include more detail. Florida is not, Palm Beach County is not one of those counties or jurisdiction that requires that. I don't know that retaliation will be exactly under these circumstances, but I think that's one of those things where you have to explore it, investigate it. And if you find information that indicates that there is, some sort of selective enforcement, and they're, choosing to select your tenant for non-renewal and other people are not being non-renewed in development, it's worth at least investigating and doing an intake and pursuing complaints if some allegations reflect that they meet the elements for a fair housing complaint. I think that is all.
Any other questions? Okay. Not. This slide is in reference to the credits for the CLE credits. We'll take a moment to write down the number.
And next week, we will be sending you a copy of the PowerPoint and a copy of the CLE credit certificate so that you'll be able to enter your Florida Bar credit in your portal.
Okay. Well, we want to thank you. Thank all the panelists for today. We want to thank you for being here and participating in our webinar. We hope that you have been informed as far as fair housing laws and actually getting involved in fair housing cases and taking on fair housing issues. Again, we thank you for participating and thank you for joining us today. Please be safe, and we will see you down the road in our next presentation. Thank you.